This court case could collapse gun-free zones nationwide. What if I told you that one court case, out of all places, New Jersey, could finally stop states from pretending they're following the Supreme Court while quietly banning carry almost everywhere? And what if that case doesn't just affect New Jersey, but every law-abiding American who carries legally? Because that's exactly what's unfolding right now. If you're new here, I'm Steve Mazzagatti, retired New Jersey State Trooper and firearms instructor. This channel focuses on understanding the law, personal safety, and responsible self-defense. Let's get into what this case actually means. After the Supreme Court decided Bruin in June of 2022, states like New Jersey, New York, California, and Hawaii all responded the same way. They said, fine, we'll issue the carry permits, and then immediately followed it with, but we'll declare almost the entire state a gun-free zone. They didn't comply with the spirit of the ruling. They looked for a workaround. Even Justice Thomas, in his Bruin ruling, said that New York can't ban an entire island like Manhattan a gun-free zone, and they did it anyway. And now that strategy may be finally hitting a wall. The U.S. Court of Appeals for the Third Circuit has agreed to rehear en banc New Jersey's post-Bruin sensitive places law. En banc means every active judge on the court, not just a three-judge panel. The case is Coons versus Plackton, and it challenges New Jersey's attempt to label everyday locations like restaurants, parks, beaches, libraries, entertainment venues as government-mandated gun-free zones. This isn't a technical footnote, folks. When a court grants en banc review, it's signaling we need to re-examine this decision very carefully. After Bruin, states had a choice. They could regulate responsibly within constitutional boundaries, or they could push those boundaries and dare the courts to stop them. New Jersey chose the second option. Lawmakers created 26 categories of sensitive places, otherwise known as gun-free zones, with more than 100 subcategories underneath them. Initially, you couldn't even carry in your own car or on private property without the express permission of the owner beforehand. The practical effect was simple. You could legally carry, but almost nowhere you actually live your life. That isn't regulation. It's an attempt to make lawful carry impractical in everyday life. This case isn't really about whether any sensitive places can exist. We already know that truly sensitive locations like courthouses during proceedings or secure government facilities have historical grounding. The real question is this: can the government declare a place sensitive or gun-free while doing nothing to actually secure it? Because when the state disarms law-abiding citizens but provides no metal detectors, no armed security, no controlled access, all it has done is create a soft target. And that's not just a legal problem, that's a real-world one. Here's what often gets lost when this debate stays trapped in legal theory. Signs do not stop violence. I did a video on this topic. The links are in the description if you haven't seen it. When a state declares a location gun-free without real security, it doesn't create safety, it creates predictability. Criminals don't care about signage. They care about vulnerability. They ask a very simple question: who here can't fight back? That's why attacks so often happen in places labeled safe or gun-free. Not because the sign failed, but because it worked exactly as intended. The founders understood this. They didn't believe safety came from the declarations or paper rules. They believed safety came from the capable citizens and accountable government. So if the state wants to take away your right to self-defense in a location, the burden shifts to them to protect you there. New Jersey's law avoids that responsibility entirely. History doesn't support that approach. The Constitution doesn't support it, and neither does common sense. When courts use the term sensitive places, they're borrowing a modern label and trying to retrofit it onto history. At the founding, sensitive places were extremely limited. We're talking about legislative chambers while in session, polling places, courthouses during proceedings, secure government buildings with armed presence, schools, but really the school restriction was meant for the students, not the adults. Sensitive places didn't include parks, sidewalks, restaurants, and the places where ordinary life happens. The Second Amendment wasn't written to protect hunting. It was written to protect self-defense in everyday life. When states redefine sensitive to mean anywhere people gather, they're no longer interpreting history, they're rewriting it. Why this case is different and why the timing matters. This case was already decided once by a 2-to-1 panel that largely sided with New Jersey. But here's the detail that changes everything. That decision sat for nearly 2 years. During that time, the makeup of the Third Circuit didn't stay static. New judges were confirmed, including the most recent addition to the court. And that matters, not because of politics, but because of judicial approach. The newest judge comes to the bench with a background grounded in text, history, and constitutional structure, the very framework the Supreme Court required in Bruin. That approach emphasizes starting with the Constitution's original public meaning, treating enumerated rights as first-class rights, and requiring the government to justify restrictions with actual historical support. That's important here, because Bruin didn't leave room for creating balancing tests or modern policy preferences. It demanded that courts ask a very specific question. Is this restriction consistent with the nation's historical tradition of firearm regulation? When the composition of the court shifts towards judges willing to apply that test as written, not rewrite it, cases like this take on a very different posture. And that's why the delay that once protected New Jersey's law may now be working against it. New Jersey plays a unique role here. It's not just restrictive, it's comprehensive. Lawmakers didn't test one idea. They passed nearly every gun control concept being pushed nationally. That's why this case matters so much. If New Jersey's law fails, it doesn't just affect one state. It undermines the entire legislative playbook being copied across the country. That's why attorneys general nationwide are watching this case closely. There's another side to this that needs to be said clearly. If New Jersey wins here, then any constitutional right can be hollowed out the same way. Imagine free speech, allowed but banned in most public places. Or religious expression, legal but prohibited anywhere people gather. Privacy, recognized but ignored when convenient. Rights don't survive on paper, they survive in practice. We know once the Bruin ruling came out, states like New Jersey, New York, Hawaii, California all got together drafting and signing into place laws that restricted carry almost everywhere as a workaround to the U.S. Supreme Court ruling. Courts exist to stop end runs around constitutional rulings. That's what this case is really testing. Here's an important reminder, folks. Nothing has changed yet. If you live in New Jersey or any restrictive state, you still follow current law. For my New Jersey watchers, I'll put a link in the description to the NJSP website for sensitive place information. But understand what's happening here. The courts are starting to push back. Judges are asking harder questions, and the idea that states can ban carry everywhere without providing security is cracking. Regardless of how this case ends, one truth doesn't change. If you carry or plan to, you own the responsibility to stay informed. Laws evolve, boundaries shift, court rulings take time. That's why we emphasize education before equipment. Knowing where you can carry matters just as much as knowing how. This is one of the most important Second Amendment cases in years, not because it's dramatic, but because it decides whether rights exist in reality or only in theory. I'll continue tracking this closely. I believe the hearing is set for February of 2026. If you want clear, responsible analysis nationally and here in New Jersey, subscribe, check the links below, and stay connected. Stay alert, stay lawful, and as always, train the mind first.